Right. Well, I think we'll start at this juncture. There's some people still filling in, but hopefully they won't miss too much if we kick off now, given that it's 11:02. So first of all, a very good morning to you all and welcome to 3PB's Judicial Review in Education series, Part 2, Exceptional Provision in Education, Section 19 of the Education Act 1996. My name's Jim Hirschmann. I specialise in education, adult and child social care law and judicial reviews related to those areas. I'm joined this morning by Katherine Anderson, an experienced education and employment law practitioner. She has particular knowledge of special educational needs and discrimination law, and she is also a published author, having recently published the book entitled A Practical Guide to EHC Plan Appeals. Just dealing with a bit of housekeeping before we kick into it substantively. There is a Q&A, so please do use that throughout the talk if you have any questions, and we will endeavour to answer them at the end. I can confirm that these slides will be sent to attendees afterwards, so you don't need to take any notes to the extent that relevant materials already on the slides. I'd just like to flag, for those of you interested, on the 9th of July will be webinar 3, which is consultation challenges in the SEN system. So just one for your diaries. But without further ado, I will proceed by telling you what to expect today. So we're going to start by setting out the law. We expect that that's going to take about the first half to 3/4 of the seminar. And then we'll go through the claimant's approach to pre-issue, the defendant's approach to pre-issue, the claimant's approach to litigating the claim, the defendant's approach to defending the claim before taking questions. So with that, by way of introductions, I pass over to Katherine to deal with the law.
Thank you, Jim, and good morning, everybody. So I'm starting with the statutory provision itself, Section 19. The section is titled Exceptional Provision of Education, but this is often referred to as alternative provision. The duty relates to children of compulsory school age. The section or subsection sets out the circumstances in which the duty arises. The duty is to make arrangements for the provision of suitable education at school or otherwise. The circumstances giving rise to it can be illness or exclusion from school, but also or otherwise, which we'll look at in more detail in a moment in relation to the case law. And it's where children of compulsory school age may not, for any period, receive suitable education unless such arrangements are made for them. The Section 19 duty is to make arrangements for full-time education unless the statute says there are reasons relating to the physical or mental health of the child, which mean that it wouldn't be in the child's best interests to have full-time education, in which case there's the duty to provide part-time education. There is a discretionary power relating to young persons, which won't be the focus of our talk today. There are exceptions in relation to the compulsory school age child relating to the last phase of compulsory schooling. There's statutory guidance issued under Section 19, which we may refer to today. But it's also worth noting that in addition to the statutory guidance, the SEND Code of Practice also refers in Chapter 10 to the situation of children with special educational needs in alternative provision. And that guidance has also been cited in some of the authorities. Section 19, subsection 5 notes that although under arrangements made under Section 19, a child might be receiving education otherwise than in a school, nevertheless, for the purposes of the Education Act, they're still a pupil, which has knock-on effects for a number of other matters. Consider, for example, the duty under Section 9 of the Education Act that the wishes of the parents should be had regard to. In subsection 6, there's a definition of suitable education, referring back to suitable full-time education. And in the guidance, there are some paragraphs which give some guidance in relation to what full-time and suitable might mean. So what I would say is that in relation to the law, there is 3 most fundamental questions. The first is to consider, has the Section 19 duty arisen in the first place? And if so, how has it arisen? The second question will be, if it's arisen, is the local authority in breach of that duty? And if so, how so? And then finally, what is the appropriate remedy, working back to the first and second questions? Now I'll hand over to Jim to take us through some of the case law.
Thanks very much, Kath. So the case law expounds the statute. It gives really good guidance as to the various circumstances where Section 19 arises and the ways in which that duty can be discharged, or in some cases was not discharged. So a good starting point for that is R&G and Westminster City Council from 2004, the Court of Appeal. The facts of the case are on this slide. A father had removed a child from school following incidents of alleged bullying and a temporary exclusion following a fight. He asked the local authority to provide home tuition under Section 19. He argued that the child had depression and stress, which was brought on by being bullied, and that, for reason of ill health or otherwise, meant the child would not receive suitable education unless arrangements were made at a school other than the one at which he was registered. He said that was the local authority's responsibility to sort out. The local authority made efforts to provide alternative education, but argued that by keeping the child on the register at the school and keeping a place available for him, it was discharging its Section 19 duty. So what did the court say? Well, first, it looked at Section 19 itself and said that Section 19 covers situations where there's a suitable school that for one reason or another, the child is unable to attend. It made clear that illness, if it prevents a child from attending a particular school, will likely prevent the child from attending any school. And because of that, Section 19 would require the local authority to make alternative provision. It made clear that an exclusion would prevent a child from attending a particular school. And in those circumstances, the local authority has to step in. And it made clear that otherwise is a bit of a catch-all in that it does cover any situation in which it's not reasonably possible for a child to take advantage of any existing suitable schooling. So paragraph 44, the court agreed that the duty is to ensure that there is available for each child an efficient educational facility that is suitable for the child's age, ability and aptitude, and any special educational needs that the child may have. If the local education authority makes available a school that does not please the parents, it is for the parents to arrange for alternative suitable education. So the point there really is that the primary duty is ensuring that a school is available. And if the child has a place at the school, it's the parent's responsibility to make sure that they attend if it's reasonably possible to do so. And if parents fail to do that, it's not a breach of Section 19 so much, but there is enforcement powers that the local authority has that it can bring to bear upon a parent. And you can see sections 437, 443 and 444 of the Education Act 96. The court also helpfully noted that if there's a situation where a school's available, but the pupil's not attending because of failings by the parents, that might be a situation where care proceedings would need to be instigated. So in short, what G and Westminster tells us is that where a child is not receiving suitable education, it is necessary to consider the whole picture in order to decide in what respect, if any, that's attributable to a breach by a local authority. There can be other causes, failings by the parent, for example, and that may render a local authority not responsible. A helpful comment that was made at paragraph 48 was, even if there's no physical impediments to the child attending school, one may be able to foresee examples where nonetheless it would not be reasonable for a child to go. And the example there is given if 3 other children at the school were facing criminal charges, which they denied of sexually assaulting the child not attending, for example, then the Section 19 duty may arise. And we'll look at a case in Newark a little bit later that looks at this in more detail. So I'll save that point, but just note it was flagged in G and Westminster as early as 2004. But I'm going to pass back to Kath to deal with the next case, which is C in the London Borough of Brent.
So Brent was a case where the child had been excluded from a school, and the arrangement was that there would be education for her at a pupil referral unit, but it was argued on her behalf that that was unsuitable for her. There were violent, disruptive and badly behaved other pupils there. So what was being sought was an order for the local authority to arrange her admission to a mainstream school, or alternatively interim education at home. The point here is that the Court of Appeal, referring back to the Westminster case, made it clear that the question here isn't whether parents are being reasonable or unreasonable in saying that they don't think the arrangements are suitable. The focus is on whether it's objectively unreasonable to expect the child to attend the school in question. So in other words, it's an objective question, not on whether subjectively parents are reasonable or unreasonable in taking the stance that they're taking. Jim, back to you.
Thank you very much. So R and Kent County Council, in this case, child had been enrolled at a local secondary school. Again, allegation of being bullied and was withdrawn by the parents. Subsequently attended a private school, but after a year was withdrawn again because of bullying and thereafter educated at home. The local authority view was that the withdrawal from a local secondary was not reasonable, that the education offered there was suitable and available to the pupil. The parents adduced evidence from an educational psychologist that it would be psychologically detrimental for him to return to the school and he needed an alternative. So again, what did the court make of that? Well, first it applied G and Westminster and said that the test is not whether the parents of a child have reasonable objections, but whether objectively the education offered is not reasonably possible or reasonably practicable to be accessed by the child. So again, it's an objective test. Is educational provision offered by the local authority available? Is it possible and accessible to the child? And the test there is reasonably practicable, not absolute impossibility. So it's an objective and strict test. The court then went through the suitable education, which was an assessment for the local authority to make. And what the local authority was able to adduce in that case was its own EP evidence contradicting that of the claimants. And the court found on balance the local authority pushback was reasonable. It was reasonable to attend the school and therefore the claim failed. Back to you, Kath.
So the Wolverhampton case is a case involving a child with an education, health and care plan. That child attended a school maintained by the local authority. And in 2016, there was an incident whereby the child arrived home on the school bus, naked from the waist down. Now, to understand all the circumstances as to how that arose, one can read the judgment. But the point is, the parents said after that incident, it was not reasonably practicable for them to continue sending their child to that school. Now, very helpfully, Mr. Justice Garnham set out in the Wolverhampton case a summary of the principles which were to be taken from the case law, in particular the cases that Jim and I have just been looking at. 5 key points, therefore. The first is that Section 19 is intended to cover circumstances in which it's not reasonably practicable for a child to take advantage of existing suitable schooling. The fact that parents may have misconceived objections to their child attending a particular school doesn't mean that the local authority is therefore obliged to step in and make alternative arrangements. But of course, I would add to that the point that I think Jim has been careful to take from Westminster, that the local authority may have other duties in relation to that child, not under Section 19, if parents are not discharging their duties under Section 7. Going back to the Wolverhampton case and point 3, there might be exceptional circumstances where there's no physical impediment to the child attending the school, but nonetheless, it's not reasonable to expect the child to attend that school. And where that question arises, as we've seen, that is an objective question to be answered objectively and not by reference to the parent's view of the facts and whether that view is itself reasonable or unreasonable. The acid test is whether the educational provision offered by the local authority is available and accessible to the child. The Wolverhampton case is also interested in terms of how the court approached the particular questions in that case. So you will recall there was an incident in 2016 which gave rise to parents' view that it was not reasonably practicable to continue to send their child to that school. And the High Court held that the parents' complaint in regard to that incident was made out in relation to what had happened and also in relation to the school's response in relation to that complaint, that the response was inadequate. However, the High Court found that was a one-off event. There wasn't a suggestion of a systemic failure, as it were. And so the school going forward was capable of providing suitable education, and therefore the Section 19 duty wasn't engaged. The other interesting point about the case is that the court considered the position if Section 19 had been engaged. And what the High Court said was actually the local authorities' offer didn't constitute full-time education. I mean, the circumstances of that case, what was being offered was a maximum of 10 hours educational assistance a week. And in the context of a child who had an education, health and care plan, the High Court said that that was not sufficient. I emphasise that the circumstances of that case were in particular that the child had an education, health and care plan. I would caution against taking that, as it were, as a rule of thumb that 10 hours won't be sufficient. And if one looks back to the statutory guidance, there is some assistance as to what the equivalent of mainstream education might mean in circumstances where, for example, the child is receiving one-to-one tuition, for example. Thank you, Jim.
Thank you. So looking at R and East Sussex County Council, ex-party Dandy, this is a case that looks at funding and the extent to which that's an important consideration. So the broad background to this case was that you had 5 hours home tuition being offered, sort of reminiscent of current times. Local authority budgets were in some difficulty, so a policy was passed by this local authority reducing, as sort of standard provision, 5 hours home tuition to 3 hours home tuition, evaluated the claimant's case, applied the policy and decided that 3 hours home tuition would be enough. Court of Appeal was sympathetic to that view, but the House of Lords was not. The House of Lords said it's a duty to provide suitable education, and in this case, 3 hours is not suitable. But what's interesting is what the court said about the relevance of resources. It said the duty to make arrangements for what constitutes suitable education is for each child. That duty will not be fulfilled unless the arrangements do in fact provide suitable education for each child. And for those reasons, as a matter of pure construction, there's no reason to treat the resources of the local authority as a relevant factor in determining what constitutes suitable education. The caveat to that, if there's more than one way of meeting the educational provision, then it's open to the local authority to choose between those options and to choose the cheaper option. So a local authority does have some scope to manage its budget, but anything it offers has to cross the threshold of suitability. Back to you, Kath.
So the Croydon case is a situation in which, on behalf of the child, an application for urgent interim relief was being sought. And the circumstances were that there had been a finding by the first tier tribunal that the relevant school in question was a suitable school. So that school, despite mother's view, was found to be suitable for the child by the first tier tribunal, and mother had appealed to the upper tribunal as well. While that was happening, judicial review proceedings were also started. The difficulty, however, was that despite the finding that the child was that school was suitable for the child, plainly the child didn't see it that way, as it were. Mother's account was that all attempts to persuade the child to go to that school were failing, and her account was corroborated by correspondence with the head teacher of the school, with social services who had become involved, and other professionals. So it was contended on behalf of the child claimant that it wasn't reasonably practicable for him to attend that school. So the way the High Court analysed that situation, Jim, could you find the next slide for me? Thank you. Was that the question of whether the education was suitable for the child was primarily one for the local authority to determine in light of the child's statement. It wasn't possible to go behind the local authority's determination, which had been upheld by the tribunal, that that particular school offered suitable education for the child. However, the separate question, whether it was reasonably practicable for the child to receive that provision, was one for the local authority to determine in the first instance, but that was subject to review with close scrutiny by the court. Now, in this instance, since the local authorities' efforts to assist mum with getting the child to school had failed, there was no further plan being put forward, it wasn't reasonably practicable for that child to attend that school. There was no evidence that his mother had been failing to cooperate with attempts to get him to school. Jim, I think...
Which I think takes us nicely onto the case of Newick, the case that I referenced earlier. Now, the question there was one where the school had decided to direct off-site and said, you can't come into school whilst we investigate allegations of peer-on-peer abuse. So one question there was whether Section 19 was engaged, and the court said two things. So first of all, starting with paragraph 32, it noted that Section 19(1) required a local authority to fill a gap where it arises by reason of illness or exclusion from school or otherwise. Now, because there hadn't been an exclusion as such, it was the otherwise part of Section 19 that was engaged. So that's action mandating that a child, against the wishes of the child's parents, must attend off-site education at another school. So it was found that one, the school had the general management power to ban from coming on site, if you like. The head teacher had that power. And in those circumstances, Section 19 does kick in. And one interesting point made at Section 20, paragraph 29 of that judgment is that a school local authority had the power to impose a safeguarding separation, so mandatory off-site schooling, for example, as a collaborative and coordinated action taken for ensuring and having due regard to the government statutory guidance for the purpose of ensuring that the educational functions of the local authority and the functions relating to the school are each exercised with a view to safeguarding and promoting the welfare of the children. So the way in which the regime works is a local authority exercises its Section 19 power. The school exercises its general management powers, and it has to do so in a way that complies with administrative law principles. And three, there's a discharge of public law duties, generally by the local authority. Just open. Yes. Good. And I'll pass back to Kath, the HXN.
Yes, so in this Redbridge case, it was two, I think, key points that are worth mentioning. So firstly, it's recognised that there may be a breach of duty under Section 19 of the Education Act, but also under Section 42 of the Children and Families Act 2014, where the child in question has an education, health and care plan maintained for him or her by the local authority. And the second point that is worth highlighting from that case is that there can be situations, and I think this is particularly relevant in the context of a Section 42 case, which our colleagues Alice and Matthew covered in their talk on Section 42 of the 2014 Act. There can be situations in which what the tribunal has ordered or the local authority has decided needs to be specified in the education healthcare plan can, in certain circumstances, be or become possible for the local authority to secure. In the context of Section 19 situation, it may also be the case that a council shouldn't be ordered to do the impossible. But in relation to providing suitable education under Section 19, there's clearly much more breadth as to how that can be delivered than there may be in the case of education, health and care plan, where Section 42 is in play. And so the court has said, yes, a council shouldn't be ordered to do the impossible, but nor can they simply give up in the face of obstacles, irrespective of the source of those obstacles. If the council is saying that what it has been asked to do is impossible, it's incumbent on it to explain what it is doing to overcome those obstacles and why it can do no more. We'll be coming to those sorts of issues when we talk about some practical situations in relation to claims and defences. And so I now turn to Jim.
Thank you very much. So that's sort of a summary of the case law in the background. So looking now at the practical issues when you're bringing or defending a judicial review claim. So starting with the pre-action stage. So the pre-issue stage for claimants, as many of you will be aware, there's a low bar to being able to issue or get permission, in that you've just got to show that the claim is reasonably arguable. There is a financial risk to a defendant if a claimant is legally aided, in that it's generally rather hard to recover costs against a legally aided claimant. But it's important as well as a claimant to consider alternative heads of challenge to run alongside Section 19. So it's already been flagged that a Section 42 breach and Section 19 breach can run concurrently. That might be important if there's an anticipated change of circumstances. It may be by the time you get before a judge, some issues have fallen away, and therefore it's important that you bring all the applicable heads of challenge right at the start. So what do you do at the start if you have a case, a parent saying, my child is out of education? The first thing to ask yourself, has the Section 19 duty arisen? Is the local authority the one in breach, or is the school, for example, failing in its duty? And what remedy is being sought? And I propose following this sort of checklist. So first of all, what limb of Section 19 is engaged? Is this a situation when there's illness or ill health that's preventing attendance at school? Is it exclusion? Is it a mandatory off-site direction? How is Section 19 engaged? Second of all, is the local authority aware of this? Have they been asked to make arrangements under Section 19? If they haven't been asked, obviously you need to bring it to the local authority's attention immediately. But what have they offered? Have they accepted the Section 19 duties engaged? And if they are, what are they offering to sort it out? Is that suitable? If they're offering something, is it going to provide adequate education for the child? And is it reasonable for the child to access that education? If there's been a refusal, what are the reasons for that refusal? Again, that goes to choosing your target very carefully. You don't want to find yourself in a position where you've judicially reviewed the local authority and they just push off responsibility and say you should have judicially reviewed another body. And can you meet your burden of discharge? What supporting evidence does the claimant have? Are there letters from the head teacher? Are there doctor's notes, for example, if there's ill health? Has the decision preventing access to school been clearly identified? And really you want to make sure you have all that evidence gathered, that you raise that evidence and put it to the local authority in pre-action correspondence before advising whether or not to issue. So I hope that checklist proves helpful for any of you considering it in the future. But I'm going to move on to the next slide and look about the actions you do when you've conducted that sort of pre-action sort of initial assessment, speaking to your client. What is the defendant likely to say? Well, they're obviously likely to consider asserting that the provision is suitable. They might suggest it's reasonably practicable for C to access what is being offered. They might say that any failure is due to the claimant, that it's impossible to put in place the provision asked for, or that the issue is academic by the time it gets to court because they take action. So the impossibility and academic elements are ones I want to just go into a bit more detail on. First of all, when you're seeking suitable provision, the court won't give mandatory relief for a local authority to do the impossible. So I think as a claimant, it's very important to be realistic about what provision can be put in place by a local authority and to specifically ask for provision of that nature. It helps just in practical terms because it makes clear to the local authority what you want to see done, but it also avoids any defence of impossibility being run by the local authority if you issue. The second element is trying to defend as a matter of strategy against the claim being rendered academic by the time you issue, incurring fees, whether under legal aid or otherwise, drafting pleadings on a case that's just going to be sorted out in short order. It may be premature to issue in those circumstances, and you might be better served focusing on constructive discussions with the local authority, perhaps a round table meeting. The matter of costs is also live. Generally, if you want to recover costs as a claimant, you need to show that issuing led to the relief that you wanted. And if the local authority can turn around and say, well, actually, we did what we were always going to do, and issuing proceedings has not sped things up at all, you might then be in some difficulty recovering costs. So that's just a strategic point to keep in mind. From the defendant side, over to Kath.
So we're looking for the purposes of today at, from the defendant perspective, the receipt of the pre-action protocol, letter before action, or pre-action letter. But of course, leading on from what Jim has just said, one would expect in many situations, the local authority will be already aware of the issue and will have been involved and engaged in correspondence. And so the point being here that if the local authority is engaging in correspondence and is taking steps and is continuing those steps, that's highly relevant to the question of whether a claim for judicial review has been properly brought by the claimant and the question of costs thereafter. But we're at a stage now where the letter before action has been received. First of all, my advice would be make sure that gets to the legal department as quickly as possible. The times for responding to such letters pass by very quickly when you have simply lost a couple of days here and there because one person hasn't passed it on to legal. Legal then need to take account of it, convene the right people into the right sorts of meetings, perhaps get advice from counsel. Then I suggest really a line-by-line check of the letter before action. What actually is the complaint or the complaints? Because, of course, it may be that in the context there have been complaints and correspondence, but now we were focusing in on what is the claim for judicial review, or rather the potential claim. Look carefully at what is being alleged factually, what is being set out as being the legal breaches, what is the remedy being sought. The next crucial issue is to arrange conferences and teamwork within the local authority as soon as possible. As I've said, getting the letter over to legal as quickly as possible is very important. But legal can really only advise on the law. What they don't know is what's been happening on the ground. They don't know the facts. You need to have conferences and teamwork within the local authority as quickly as possible. Firstly, to ascertain what has been happening, but also what can be done going forwards. So what is being done, what isn't being done, and why. Then it's necessary to come up with an agreed action plan and some agreed internal timeframes that mean that the local authority can respond within the timeframes set by the pre-action protocol. It may be that this is a case where the local authority is taking a position that Section 19 doesn't apply. But it may be that a Section 19 duty has arisen and the local authority accepts that. And the question is, why are arrangements not sufficient? Why is whatever the provision is not working? What's getting stuck? What is the provider not doing or not able to do? And of course, there's a question of what is the role of the school or college here? Is this a situation where the school does have responsibility for this provision? Why is that not working? Why is that not suitable? If it's not suitable, well, what are the facts? And again, what is not working? What is getting stuck? Again, if one is liaising with providers, if one is liaising with school or college, again, that reinforces the importance of getting these investigations as to what's been happening and what can be done about it as soon as possible within the timeframes. Now, plainly, if there are issues being raised that parents are being in some way obstructive, that they are not enabling their child to access what is being offered, providing, one needs to look into the facts of that situation very carefully to understand exactly what parents' position has been, exactly what they've been saying, and exactly what has been happening. Sometimes there can be some sort of view taken that parents are being obstructive, but one has to look extremely carefully as to what exactly has been happening and whether that's really borne out on the facts. Because, of course, there are always two perspectives on anything, and parents may well feel that they have been making very valid points which haven't been listened to and addressed. And so that takes me to this question of communication. Quite often, when local authorities are challenged by parents in correspondence, and particularly when there's intimation of a legal dispute, certainly from parents' perspective, there may be this sense that the local authority goes into a bunker and doesn't communicate. And it may be that the sense that the local authority isn't communicating has arisen before that. A local authority may consider from its own perspective that the local authority officers have been working extremely hard on an issue or to resolve an issue or to make arrangements provision. But if parents are not seeing that, if on the ground they're not getting the provision, that's not being put in place, and from their perspective it doesn't look like anything is happening at all, that plainly will not only give rise to the fact that we have this situation of dispute and a letter of before action, but also that there may be a lack of trust that has been created now, which means that certain suggestions perhaps as to how to resolve the issue going forward won't immediately be met with trust by parents. Good communication, however, can really help resolve that if the local authority is telling the parents what is going on, what they are doing, and providing them with a realistic assessment of what's happening and when it can be done by, not simply we are making these efforts with no clear time frame set at all as to when those efforts are likely to come into fruition. So then again, some questions, as it were, not a checklist as such, but questions the local authority maybe wanting to consider when they're analysing what is this complaint. So first of all, as I've said, are we dealing with a situation in which the duty has arisen? And if we don't think it has, why are we taking that position? And is the local authority in breach? This may well be a situation in which the local authority entirely accepts that the Section 19 duty has arisen and that they are not at this time making provision because, for example, they can't secure a home tutor. For example, they know that they're getting difficulty obtaining one, and they're making every effort to do that, but they haven't been successful as yet. What remedy is being sought? Because it may be that parents are saying on behalf of child, well, we want some home tuition, or we want something else. It may be that the dispute, therefore, is possibly not that parents are saying nothing is being done, but what is being done is inadequate. So the question, therefore, would be, in such circumstances, is provision suitable? Why do the local authority believe that it's so? And is it reasonably practicable for the claimant to access what is being offered? So not simply is it being provided, but can the child access it? And that's particularly relevant in a case where the child has special educational needs. Is the local authority position here that the duty has been discharged and any failure to provide is due to the claimant? Is this an obstruction case? Is this simply where parents are taking a position which may to them seem perfectly reasonable, but objectively is not a reasonable position for them to take? In relation to impossibility questions, I would say be very careful on for a local authority to consider that this is a situation where they are saying it's not possible. It's difficult to bring an impossibility defence, as it were, or rather defence. I wouldn't say so much defence as a reason why the court shouldn't make a mandatory order. In a Section 42 case, in a Section 19 case, I think it would be much harder for a local authority to genuinely and credibly argue that it's not possible for them to put alternative provision into place in a particular case. So I say consider that with great care. Impossibility doesn't mean that you have contacted a few tutors and none of them have got back to you yet. Showing impossibility requires something far, far higher than that. So if the local authority is going to take that position, its legal advisors should be scrutinising very, very closely what steps have been taken and what further steps could be taken. The question whether this matter is now academic, of course, is perhaps more relevant because quite often what we're dealing with here is a sort of moving situation. So it may be that at a certain stage in events, the local authority was looking to make arrangements, but hadn't made them as yet. But as time moves on, some of those arrangements may be in the process of being put in place. Tutors may have been contacted, they may have been secured, they're coming in next week, and so on. So where the local authority is saying, for example, yes, we accept there's a Section 19 duty here, and we accept that the provision isn't in place as yet. If it is saying, but it will be in place next week, for example, which would render any claim academic, again, be very sure of your facts, be confident that that is indeed going to happen. So that one can be quite clear as to whether this is going to be academic or not in the context of a moving situation. Okay, over to Jim.
Thank you. So, pre-action protocol has been completed and you're at the stage of considering whether to issue. So at this stage, I'd expect there to have been significant correspondence from the claimant with the defendant. We'd want to understand whether they accept Section 19 is engaged, whether they accept that they're responsible and what they're doing about it. So I'd sense check the defendant's pre-action protocol response very carefully. I'd want to consider whether we've done everything we can to move it forward without needing to issue. If I form the view that we are going to issue, I'd want to make sure that the defendant has been put on notice of that. I, as a solicitor, would expect, well, I would probably be looking to instruct counsel, or as counsel rather, I would expect to be instructed by a solicitor to do the statement of facts and grounds. Within that statement of facts and grounds, I'd be thinking very carefully, can I evidence the case? I'd be wanting to make sure when I was advising my solicitor clients that we have sufficient evidence to persuade the High Court that our claim is made out, and that is insofar as possible insulated from any evidence that the defence is likely to file. I'd want to consider interim relief or expedition. Is there urgency here? Do we need an urgent hearing from the High Court? Or is this a matter that can wait a month or two to get before a High Court judge and be properly determined? Which is linked to remedy, really. What do we want here? What's our strategy? What does the package of care ultimately look like for the claimant? Are there negotiations that are ongoing? If the local authority is not acting, quickly, if I'm not persuaded from what I've seen that the local authority is going to get its act together and discharge its duty, then that may be a good reason to issue and seek a mandatory order to force the local authority to act promptly. And that hopefully will also speed up any negotiations that are ongoing. There's a duty in judicial review to issue promptly. Just because there's pre-action protocol correspondence ongoing, it's not necessarily a reason not to issue at the point where the breach is clear, and it's not clear when it's going to be remedied. So making sure we comply with promptness, I would be looking to issue once we've put the defendant on notice and it's clear that they're not discharging their duty. And after issue, it's really a question of hearing preparation, making sure that there's capacity both within the solicitor team to have conferences with the client, to look at any updating evidence that comes in, to ensure that any defence filed by the respondent can be properly considered, that our advice can be taken promptly, that an application to amend grounds, if that proves necessary because matters move on, is considered promptly, and not just that the case is issued and then sort of just left to run. It should be kept under continuous review. You, Kath.
So some hints and tips in relation to after issue for defendant local authorities. Perhaps it should go without saying, but obviously check the court orders carefully to make sure that you know exactly what you have to do and when you have to do it by. I advise instructing a counsel early so that you clearly have somebody who is up to speed as soon as possible, hitting the ground running with all matters, and that you have early advice as to how to proceed through the litigation. Obviously, setting out grounds of resistance. It may be that what you are looking at isn't factually complicated, or it may, however, be much more factually complex to set out exactly what has been happening, particularly when you are dealing with a moving situation. So in relation to law, that's something that you would expect those who are legally instructed to deal with, but facts, you need to allow sufficient time to make sure that the factual response is correct and up to date. In terms of evidence, again, this will turn entirely on the factual situation in question, but think carefully about who is going to be the relevant provider of witness statements. Is it enough to provide, as it were, a generic, an overview, as it were, from the local authority officer who has the oversight of this, or are you going to need evidence that's more specific from, for example, from school or from other local authority officers who have had direct involvement, perhaps, in relation to the matters in question, where you need evidence in relation to decisions that have been made, for example. So again, this is a question of considering both witness statements, but also what evidence you may need to back up what is being said in relation to the witness statements. This will be fact-specific, but requires careful thought. Chronologies, of course, have to be agreed. Negotiations, of course, need to be considered carefully. This may be a situation where negotiations, discussions between the parties have predate the start of the proceedings, but it may well be having regard to the overriding objective, as well as the local authority's statutory duty under Section 19, that it should be continuing to try and put in place the provision that it needs to put in place under Section 19 and to communicate that with the claimant. Further internal action, again, as I say, the Section 19 duty is there. If it is in play, the local authority, again, may be needing to take further internal action to action and put things in place before it turns, or rather simultaneously as it turns to preparing for the hearing itself. So I think now we have a bit of time for questions. Is that right, Jim?
It is. So just opening up the Q&A. The first question was, can you please explain more about one-to-one tuition as opposed to full-time provision? And now I'm happy to take that in first instance, Kath, but you may have, things to
Yes,
add.
go for it, Jim.
Um, I think the broad point is, suitable full-time education. One-to-one maybe less than sort of, the full school week expected, because, if you get that one-to-one tuition, you're likely to progress more quickly. You can probably cover more content, and you're supported more to sort of embed that content learning. But I would be very cautious if I was a local authority to expect to get away with, I don't know, 10 hours a week or something like that in view of the cases we've seen. It's very much case by case, looking at what can be done and looking at the ability of the pupil to engage with the provision offered. So there's various guidance that we've referred to within the slides that you should have regard to in that relation, but I think it's case by case.
Yes, I would simply add to that in the guidance on children who can't attend school because of health provisions, sets out that, for example, if a child receives one-to-one tuition, the hours of face-to-face provision could be fewer, as the education may be more intensive, but not necessarily in the case of that particular child. So whilst indeed, one may not need to match full-time education in terms of literally the number of hours. One would need to be very careful as to what exactly was the content and the delivery and the needs of the child to say that a lesser amount amounted to being suitable. So I have a question. If a child with an education, health and care plan isn't attending school due to school-based anxiety and parents want education otherwise than at school named or provided for through the EHC plan, I would say, rather than named in Section I. But the local authorities are of the view that the child's currently unwell and education is being provided by fulfilling their Section 19 duties, and they don't agree to naming section to making education otherwise than at school part of the EHC plan. Is the local authority correct to take that view, or should it name it? Well, I think the answer here is that there's a very specific statutory test in relation to education otherwise than at school in the context of an education, health and care plan under Section 61 of the Children and Families Act. And there's guidance in case law as well. The test is whether it would be inappropriate for the provision in the Section F of the Education, Health and Care Plan to be made in a school. There's guidance in case law as to the sorts of questions that would be relevant to that. So the point being, the local authority must answer the Section 61 question. That gives their answer in relation to what they should be doing in relation to the Education, Health and Care Plan. In relation to the Section 19 duty, plainly the local authority also needs to take into account what's in the Education, Health and Care Plan and are they delivering that under Section 42. So this will be fact specific, but one needs to take the different legal questions in turn.
Yeah.
Jim.
No, I agree with that. And then the next question is, one of the major problems in securing Section 19 education for children out of school due to anxiety is securing evidence, particularly as some schools and LAs purport to refuse to accept GP evidence as some GPs refuse to give it. Any thoughts about how to deal with this? Well, I mean, it's interesting. I've certainly seen some sort of GPs push back about giving sort of expert reports or giving formal letters without being sort of paid a fee for it. In those circumstances, I think, it's about pushing back to the surgery and seeing how much you can get from them. If the family have the resources available, there's always the possibility of instructing an expert accordingly to give that view. But if not, you can give evidence, a statement from the parent about the symptoms the child has, perhaps what the parent's been told at appointments with the GP about the number of appointments, any prescriptions. And it's about thinking creatively, I think, to just get the best evidence you can in the circumstances of the case. But for the court, the test would be a balance of probabilities. Um, and I think it would be a brave local authority that would push back on the basis that there isn't any evidence at all. I think they'd want to be getting something sort of more positive than that, sort of from the school about how they've been presenting or from their own engagement with the parents to sort of prove the point. Might even want to instruct their own expert or GP to review the child's medical notes.
So here's an interesting question regarding evidence to rebut impossibility if the local authority is advancing that line. Would you advise obtaining evidence to show that it can be delivered within area? For example, quote or a statement from tutors or therapists to show that it can be sourced? And if so, would you include costs given the Tandy decision? Well, I'd say, first of all, yes, I absolutely think it would be a good idea if there's evidence that it can be delivered in area for a claimant to put that forward. I mean, what better way to rebut any suggestion that this is impossible than to say, no, it's not, because here's what you can do. And that's a legal position. But also, of course, if indeed there are tutors and therapists which parents that are satisfied would be suitable and appropriate, and they're putting those forward to the local authority, that can certainly shortcut, as it were, the process through which the local authority is going. If they are genuinely struggling to source both the suitable tutors, but also ones which parents would consider to be suitable and appropriate. So I certainly would say that is a good idea. Obviously, have regard to the circumstances in the case, because of course there may be circumstances in which for various reasons the case that the local authority is advancing needs to be met in a different way. Another question: would you include costs? I imagine that in circumstances in which availability has been investigated in any event, there will be some information to share about costs. And that can be certainly relevant in circumstances in which the local authority has to look into not only meeting the duty, but it can meet the duty in various ways and take costs into account in that regard.
An interesting question on Newick, which is what steps would you expect a school to take when exercising its general management powers to ensure that their decision to require a child not to attend its premises is not vulnerable to challenge? The starting point is general admin law principles. There's got to be a reasonable decision. There's got to be a basis to exclude, from premises. I'd suggest quite a high threshold of sort of safeguarding risk about attendance on premises. I'd expect it to be no longer than is necessary to investigate fully. I'd expect it not to be a disciplinary sanction at that point, probably if it was the general management power, because what you don't want to do is to be seen to be excluding through the back door. So those are sort of the headline things I'd think about, but it's a developing area of law, I think, and I think the limits of the power are still to be tested. Noting the time, it's now noon. I think there's 1, 2, 3, 4, 6, 7, 8. I think 9 more questions to go. Kath, I don't know how you're set for time, but I'm happy to carry on, accepting that some participants might need to leave.
Yes, we can do that. We can run on a little bit longer.
Great. So we have a child separated, parents who are living across 2 local authorities. Does the local authority need to provide the provision at the times when the child is residing outside of their area? That's an interesting point, a question that often arises in relation to school admissions and the area in which the pupil is to be educated. Ultimately becomes a test of reasonably available, doesn't it? Applying the case law on section 19. But really that might be a question of normal schooling generally, because section 19 would not ordinarily be engaged if there's attendance at school, so it might be more of a school admissions question. Barrister acting on direct public access instructions. Well, I'd say I'd only accept public access if my client's able to sort of fulfill the role of a solicitor in broad terms, in terms of marshalling facts and so on and so forth. So I'd expect them to take on the role of fact gathering. But I'd advise them on the areas, sort of the type of evidence that I need, and would go from there.
In relation to what circumstances can an alternative provision, such as a PRU, be named in an EHCP? Well, I would say potentially a broad range of situations. The test for what should be named in an education, health and care plan in Section I is it's the school or other institution to be attended by the child or young person. And the circumstances in which it's named need to revert back through the statutory process. Parents have, or in the case of a child, its parents have the right to request a particular school or institution to be named if it falls within certain categories, which are set out in Section 38. It seems possibly unlikely that they would be requesting an alternative provision, but they might be. And there may be a number of reasons why the local authority considers that would be appropriate. But of course, we are looking at a situation in the circumstances of an education, health and care plan where these are reviewed annually. So it is usually the case one's looking at a longer term provision, but there could be a number of situations in which something might be appropriate. I think it's difficult, in summary, to answer that without knowing the specific facts of the particular case.
Dealing then with the technology and online schooling affecting the ease of imposing Section 19 duty, or if it will in the future. I mean, I certainly think online provision could, in principle, meet need in certain situations, in certain circumstances. But yeah, case by case.
Absolutely. And what I'd add to that is that in the statutory guidance that there are some paragraphs on the use of digital resources. It said that local authority and the child's home school, which means that the school where the child's on roll, should consider the use of digital resources to aid learning. But digital technology should be used to complement face-to-face education rather than being used as sole provision. That's the guidance. But it says that in some cases, the child's health needs may make it advisable to use only digital learning for a limited period of time.
That's very helpful. There's a question there which I can take then on pre-action protocol correspondence and ongoing correspondence impacting costs. And the reason for that really is, costs tend to follow the event. So the winner can generally recover their costs from the loser. And the way the argument generally goes is if the case would have settled without issuing proceedings, then the proceedings have not led to a victory for the claimant, and no costs are therefore recoverable. So that's broadly the argument. Croydon's the main case in relation to costs in judicial review proceedings.
So question, can education otherwise than at school be specified in Section F of an EHC plan, but Section I still name a grammar school in Section I as part of a transition plan and re-education? I assume what that means is to transition plan into the grammar school, integration into the grammar school, or indeed any school. So I think the starting point is that yes, an EHC plan can have part education otherwise than at school in F, and in Section I, a school to be attended. And really, I think this is a fact-specific question as to whether we are looking at a relatively short transition plan or a relatively long one. If one is looking at something that's going to be a substantial and more prolonged period of education otherwise than at school, that should be set out quite clearly in Section F. If one's actually looking at a very short transition plan going into a school, then the view taken in my experience by many tribunals is that isn't really education otherwise than at school. That is just a short transition, perhaps taking place over a few weeks into school. So again, I think it needs to be a question that's answered in relation to the very specific facts of the case and what is going to be needed in terms of a transition plan for this particular child into that particular school.
Mm-hmm. A question here then about education, health and care plans. In circumstances where Section 19 duty is accepted, child cannot go to school, is the local authority under duty to provide all of Section F whilst the child is not in school? And if so, what are the risks? Well, Kath, you may have some thoughts on this, but sort of my instinct would be to say that first of all, it's a non-delegable duty to make sure the provision in the EHCP is secured. So you have a duty to secure it, sort of no matter what. If you accept your Section 19 duty, then you really should be looking at the local authority to put the provision in at home. If circumstances have changed such that a child's needs have changed, then it may be a case where you want to revise the contents of the education, health and care plan to sort of be updated and then meet that provision. But the practical point, I suppose, is in terms of mandatory relief, if it's impossible, literally impossible to provide that within the EHCP because of a child's ill health, then it's unlikely that a court would order mandatory relief. But the proper response has to be in those circumstances, because needs have changed, to consider updating the plan, I would have thought.
Indeed. And so then finally, I think that the answer to the question is full-time defined in statute. No, as I say, there's indication to the guidance as to what it may mean, but no, not defined in statute.
Yeah. And then the last question about direct access and the barrister having authority to conduct litigation. Well, I don't have that authority, so I'm less sure about that. But what I will say, in terms of not being able to afford a solicitor and needing a lawyer's input, I can understand that, and direct access can be an option in those circumstances. And I suppose the reality is for direct access, it's usually expected that the direct access client will be able to conduct litigation themselves. Otherwise, it wouldn't be suitable for direct access. And if they want a barrister to conduct the litigation, then of course can make inquiries with someone who has a litigation certificate extension. So I think deals with the questions, and I think it just suffices now to close, which I think is back to you, Kath. But from me, just thanks to everyone. Lovely seeing you.
Thank you very much, everybody, and goodbye.